based of the summary case of Ladbroke and Co. versus Todd, 1914, the plaintiff had drawn a check and sent it to the payee by post. The letter was stolen and the thief took it to the defendant, a banker, and used it to open an account. In doing so, he forged the payee's endorsement. The defendant believed him to be the payee. He was not introduced to the bank and no reference were obtained. The defendant opened the account and the check was specially cleared at the request of the thief, and he drew out the proceeds on the next day. On discovering the fraud, the plaintiff brought an action against the defendant for conversion. One question raised was whether the account having been opened by payment in all the check to be collected, the defendant could be properly regarded as having received payment for a customer.
Assalamualaikum warahmatullahi wabarakatuh and hi, my name is FATIN binti AZMAN from class JBA 1195B with matrix number 2020820622. In this video, I will explain what related to the case Ladbroke and Co. versus Todd 1914. But before I go further, first of all, I will explain the definition and nature of a banker and customer. Banker is a person carrying on the business on banking by receiving money or instruments representing money on current accounts, honor checks drawn, and collects the proceeds of checks which his customer has placed in his hands for collections. In Ladbroke versus Todd, the word customer signifies a relationship in which duration is not of the essence, and that a relationship began immediately an account was opened and checks paid in for collection. Next, I will continue with what is related to the case of Ladbroke and Co. versus Todd 1914. So, this case is related to statutory protection, which is under the topic of protection for the bankers. And for your information, statutory protection under Section 85(1) of the Bills of Exchange Act 1949, where a banker must act in a good faith without negligence when collecting checks from a customer. As a result, the bank will bear no liability to the true owner. This means that the collecting banker is protected under this rule if he collects money on behalf of the customer honestly and without carelessness. However, if the banker acted in good faith but negligently, the banker is not covered by Section 85 of the Bills of Exchange Act 1949. For example, the banker may have been negligent in creating the account for the customer by failing to seek references about his background, such as his employer's name, or verifying the validity of a reference provided by the customer. This situation has already occurred in this case, which is the banker's mistake conducted as the payer and opened a bank account. Next, I will leave it to the next presenter to explain more about this case.
Next, we will proceed with the court help.
Payment had been made for a customer because the account was already opened when the check was collected. The drawer then forwarded a new check to the actual payee, assigned his ownership of the stolen check, and filed a lawsuit against the bank in an effort to recover the money they had received and used as a proceed from the bank collection of the stolen check. Before opening an account, it was a standard procedure for a banker to get a satisfactory introduction or reference. Although the banker in this instance behaved in a good faith, it was obvious that he had failed his duty by failing to take any step to protect the interests of the real owner of the check, therefore disqualifying him from a Section 82 of the 1882 Act protection. The banker would have been eligible for the protection, but he lost it due to his negligence in failing to find an introducer. Furthermore, the court found that a relationship existed between the banker and the client as soon as the check was presented to them, not when it was paid.
So finally, we jump to the end of the case. As a word of the case, I conclude that negligence on behalf of bank is horrible and will suffer losses and damage imposed by the court. It is a duty of the banks to always ensure the authentication of their customer by make a proper verification from an acceptable of third party before opening any account. As a banker, they needs to check all the details of the check owner before the customer draws their money. This case has shown that an account holder is not properly introduced by a bank. Even the bank had acted in a good faith, but they was negligent. Then they had lost it owing to his want of due care. In the consequences, the banker is not entitled to protection because they lost the money and